In this lecture, we will be covering chapters 28, 29, and 30. So let's get started with chapter 28, Employer and Employee Relations. The creation of the employer and employee relationship. This relationship arises from a contract of employment, either express or implied. The employer-employee relationship cannot be imposed, so one person cannot be forced to go to work for another. Employers may hire whomever they want. Employees have the right to choose who they want to work for. The relationship between the employer and the employee cannot exist without consent. Length of the employer-employee contract. An employee discharged without cause may recover wages due up to the end of the contract period for the employer. Seldom does either party mention the length of the contract period. Therefore, the terms of compensation can be determined by looking at the length of the employment contract. Most situations have an indefinite length for the contract, and either party will terminate at any time for no reason at any time. This is referred to as employment at will. Employment at will is where either the employer can terminate the employee for no reason and without any notice. Likewise, the employee can quit the job for the same reasons. And this type of employment, again, is referred to as at-will employment. So, for example, an employee paid by the hour may be discharged without liability at the end of any hour. An employee paid by the week or by the month, as are many office employees, has a term of employment of 1 week or 1 month. In other words, you determine the length of the employment contract basically by the pay periods. If you're an hourly wage worker, well, then you can be fired after your last working hour. If you get paid monthly or bi-monthly, then at the end of either one of those terms, the employer can fire you without having any additional liability to you. Many employees have significant job security and cannot be discharged without good cause. Determination of contract terms. Terms other than compensation are stated by law, custom, employee handbooks, and potentially union contracts. Some courts hold the employer's written policy manual constitute the terms of employment. Union contracts. Employees begin by agreeing with unions to provisions of employment which apply to large numbers of employees. As an agent of employees, the union speaks and contracts for all employees collectively. This is known as a collective bargaining agreement. A good example of this type of union is the NFL Players Union. Duties and liabilities of the employer. The employer has the duty to exercise care. This rule imposes liability on employers if their negligence causes harm to an employee. An employer has the duty to provide a reasonably safe place to work. An employer must furnish its employees a reasonably safe place to work. Duty to provide safe tools and appliances. An employer must provide safe tools, machinery, and appliances to its employees so they can conduct their work in a safe manner. An employer has a duty to provide competent and sufficient employees for the task. An employer has liability for all injuries to employees directly caused by either an insufficient number of workers or a lack of skill of the workers. Employers have a duty to instruct employees with reference to the dangerous nature of employment. Jobs that use machinery, chemicals, electric appliances, or other hazards are examples. An employer must provide instructions to employees to avoid harm to those employees. Now, if an employee is injured, there are common law defenses that the employer may be able to raise. One would be contributory negligence by the employee. This particular rule states that employer can escape liability for breach of duty if the employer can establish that the employee's own negligence contributed to the accident. The act of a fellow servant, this rule allows an employer to avoid liability by proving the injury was caused by a fellow servant, or in other words, a fellow employee. Assumption of the risk, so a risk assumed by the employee. This rule states the employees assume and accept these normal risks of the jobs at the time that they voluntarily accept employment. Statutory modification to the common law. Statutes have modified the defenses that we just went over that an employer can take when sued for damages by an employee. Employer defenses have been greatly limited in states where statutes have been enacted establishing workers' compensation. The Occupational and Safety and Health Act, OSHA, and Federal Employers Liability Act and the Jones Act are all statutes designed to modify the employer's defenses to limit them to the benefit of their employees. Workers' compensation, an employee or relatives of an employee may recover damages for injury to or death of an employee. Workers' compensation laws allow recovery for work-related injuries or occupational diseases. Administrative judge or board hears a workers' compensation claim. The decision can be appealed to a court of law. Workers' compensation laws allow employees to sue a third party for the injury. So under workers' compensation, if you're injured on the job, you are guaranteed to receive health medical treatment and compensation, but in exchange for that, you give up your right to sue your employer. However, if you can show that your injury was caused in part or completely by a third party, then you are not barred from filing a lawsuit against that third party for the injuries that you sustained. Occupational Safety and Health Act. This act is designed to ensure safe and healthful working conditions. The Occupational Safety and Health Administration issues standards with which employers and employees must comply. The doctrine of respondeat superior imposes liability on an employer for torts caused by his or her employees. to be liable, the injured party must show that the employee caused the injury during the time of their employment. So normally what you have to show as the plaintiff is that the employee was acting within the course and scope of their employment at the time that they were negligent and caused injuries to you. At that point, you met your burden for the doctrine of respondent superior, and the employer is going to be responsible for the negligence of its employee. The employee's duties to the employer: job performance. Duties required by the job must be performed faithfully and honestly and to advance the employer's interest. Business confidentiality. Trade secrets or other confidential business information must not be revealed. Granting of right to use inventions. This is also referred to as the shop right, and this is the employer's right to use an employee's invention without payment of a royalty. Inventions belong to the employee who devised them in the absence of a contract. The Federal Social Security Act, old age and survivors insurance, assistance to persons in financial need. These are two areas covered by the Social Security Act. Also, unemployment compensation and disability and Medicare benefits. The way the Federal Social Security Act is financed: both employer and the employee pay a payroll tax, the FICA, of an equal percentage of all income earned in any year. This tax finances the unemployment compensation part of the Federal Social Security Act. Okay, let's do our chapter review questions for Chapter 28. Question 1. How is the relationship of employer and employee created? The relationship of employer and employee is created from a contract of employment, either express or implied, by conduct that demonstrates that the parties agree that one is the employer and the other is the employee. Question 2. How may the terms of compensation determine the period of an employment contract, and what does this mean to employers? The terms of compensation determine the period of an employment contract when the length of time used in specifying the compensation constitutes the employment period. To employers, this means an employee may be discharged without further liability at the end of any employment period. Question 3. What recourse does a non-at-will employee have when discharged without good cause? When discharged without good cause, a non-at-will employee may sue the employer for money damages and, in some cases, to be restored to the job. Question 4. If an employment contract does not state any terms other than the compensation, how are the other terms determined? If an employment contract does not state terms other than the compensation, the terms are determined by law, custom, employee handbooks, and possibly by union contracts. Question 5. If an employer who has a contract with the union still makes a contract individually with each employee, what meaning does the contract with the union have? An employer who has a contract with a union may contract individually with each employee, but the union contract binds the employer to recognize certain scales of union wages, hours of work, job classifications, and related matters. Question 6. How has the statutory modification of an employer's common law defenses made it easier for an employee to win a case? The statutory modification of employers' defenses under the common law has made it easier for employees to win cases because of limits on the employer's defenses. An employer is liable even if the employee is contributory negligent, for example. Question 7. Under what circumstances can an employee who is covered by workers' compensation normally be unable to recover when injured at work? An employee who is covered by workers' compensation normally cannot recover for a willfully self-inflicted injury or an injury sustained while intoxicated. Question 8. When is an employer liable for injuries that employees cause to third parties? An employer is liable for injuries that employees cause to third parties when the employee committed the injury in the course of employment or when caused by the employer's failure to enforce safe working procedures, not providing safe equipment, or not employing competent employees. Question 9. When no contrary agreement has been made, to whom do inventions by employees belong? When no contrary agreement has been made, inventions belong to the employee who devised them, even though the time and property of the employer were used in their discovery, provided the employee was not employed for the express purpose of inventing the things or the process or processes that were discovered. Question 10. How are the life and annuity insurance benefits of the Social Security Act funded? The life and annuity insurance benefits of the Social Security Act are funded by a payroll tax of an equal percentage of all income earned in any 1 year up to a specified maximum paid by the employer and the employee. Chapter 29, Employees' Rights. The Civil Rights Act of 1964. This act applies to employers who have 15 or more employees who affect interstate commerce, or labor unions with 15 or more members. It only applies to Congress in terms of U.S. government. Title VII of the Civil Rights Act makes it unlawful employment practices for an employer to fail to hire, discharge, or discriminate because of the individual's race, color, religion, sex, or national origin. These are referred to as protected classes. Discrimination is claimed on either of two theories: disparate treatment and impact. Disparate treatment, intentional discrimination against a particular individual. In this type of discrimination, the plaintiff must show they belong to one of the protected classes and they were qualified for the job or perform their job well. Disparate treatment, the plaintiff must show that he or she suffered an adverse employment action and a person not in the protected class got the job or did not suffer the adverse action. Disparate impact also includes a fair policy that disproportionately affects a protected class. An employee must show an action taken by the employer which on its face appears to be fair, but in practice it negatively and disproportionately affects a protected class of individuals. Sexual harassment. Title VII of the Civil Rights Act protects an employee on the basis of sex against an employer who engages in or allows unwelcome sexual advances, resulting in a hostile work environment. A hostile work environment exists when harassing conduct alters the terms or conditions of employment, creating an abusive work atmosphere, and it is based on the victim's membership in a protected class. An alleged victim of sexual harassment must show the environment was one which an objectively reasonable person would find abusive. Additionally, the victim must show the environment was abusive. If these two requirements are met, the environment alone is actionable under the Civil Rights Act. The EEOC, Equal Employment Opportunity Commission, hears complaints alleging violations of the Civil Rights Act and other laws. The Equal Pay Act. This act requires employers pay men and women equally for equal work. To be equal work, the jobs must be performed under similar working conditions and require equivalent skill, effort, and responsibility. An employer is not required to pay equally if the basis of payments are a seniority system, a merit system, quantity or quality of production, or a differential resulting from any factor other than sex. Age discrimination in Employment Act. This statute prohibits arbitrary age discrimination by employment agencies, employers, or labor unions against people age 40 and above. This does not prohibit consideration of age when employing, but discrimination is prohibited in the job if it is based solely on the employee's age. The Americans with Disabilities Act prohibits discrimination against qualified individuals with disabilities. A disability requires two elements: a physical or mental impairment and a substantial limitation of one or more major life activities. Testing in the workplace. Polygraph testing. This is a lie detector test used to determine whether certain employees violated workplace rules and to screen applicants for employment. An employer may not use this test or the test results as the basis of the employment decision adverse to an employee who took such a test. Polygraph testing. Private employers may not use polygraph tests unless the employer is investigating a specific incident of economic loss, such as theft or industrial espionage or sabotage. The employer provides security services. The employer manufactures, distributes, or dispenses drugs. AIDS testing. Courts have determined a blood test to be a search and seizure in direct violation of the Fourth Amendment. To determine whether a search is reasonable, the courts will weigh the intrusion of the procedure with the interest said to justify the intrusion. Drug testing. The United States Supreme Court has recognized 3 government interests which justify random drug testing: maintaining the integrity of employees in their essential mission, promoting public safety, protecting sensitive information. Employers are free to terminate at-will employees who refuse to take drug tests. DNA testing. Employers might require it if employees for 2 reasons: to make employment decisions to exclude people with a genetic defect, such as people who are at greater risk for certain diseases, or for identification purposes. Employers should ascertain their legal rights before using DNA tests in making hiring, promotion, or salary decisions. Courts have upheld the legality of requiring DNA samples for criminals. The Family and Medical Leave Act. This law allows an employee to take an unpaid leave up to 12 work weeks in a 12-month period on the following occasions: because of the birth, adoption, or foster care of the employee's child, to care for the employee's spouse, child, or parent with a serious health condition, because of a serious health condition that makes the employee unable to perform his or her job, because of an emergency from an employee's spouse, child, or parent who is a military member on active duty. An employee may also take up to 26 weeks of leave in a 12-month period to care for certain service members with a serious injury or illness. Plant closing notifications. A business which employs 100 or more employees must give 60 days written notice of plant closing, resulting in an employment loss for 50 or more employees. Notice must also be given for a mass layoff which occurs during a 30-day period for 33% of the full-time employees, at least 500 full-time employees, smoking. The right of employees to be protected from secondhand smoking is protected by state laws and restrictions at the workplace. Many other rights available to employers and employees under federal statute include the Rehabilitation Act, the Pregnancy Discrimination Act. Let's review our chapter review questions for Chapter 29. Question 1. What does the Civil Rights Act of 1964 make unlawful? The Civil Rights Act of 1964 makes it unlawful for an employer to fail to hire, discharge, or to in any way discriminate against anyone with respect to the terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin. When does a hostile work environment exist? This is question 2. A hostile work environment exists when harassing conduct alters the terms or conditions of employment, creating an abusive work atmosphere, and is based on the victim's membership in a protected class. Question 3. What remedy are successful plaintiffs in Title VII cases entitled to? Successful plaintiffs in Title VII cases are entitled to a remedy that would put them in the same position they would have been in if the discrimination had not occurred, such as corrective action by employers, notices about sensitivity training, reinstatement, promotion, payment of lost benefits, and attorney's fees. Question 4. What are the exceptions to the pay requirements of the Equal Pay Act? Exceptions to the pay requirements of the Equal Pay Act can be made if the payments are made on the basis of seniority system, merit system, quantity or quality of production, or a differential resulting from any factor other than sex. Question 5. Under what circumstances does the ADEA allow age discrimination? The ADEA allows age discrimination when age is a true occupational qualification, such as the rule that commercial pilots cannot be more than 60 years old. Question 6. Who is excluded from the definition of employee under the ADEA? Under the ADEA, the definition of employee excludes people elected to state or local office and people appointed at the policy-making level. Question 7. Does the ADA prohibit employment discrimination against all people with a physical or mental impairment? The ADA's prohibitions of employment discrimination apply only to persons whose physical or mental impairment significantly limits a major life activity such as caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, working, and the operation of major bodily functions. Question 8. In what ways does the EPPA limit an employer's use of a polygraph test with respect to employees? The EPPA prohibits an employer from retaliating against an employee who refuses to take a polygraph test and may not use the test results as the basis for any employment decision adverse to an employee who took such a test. Question 9. When may an employer use a polygraph as part of an ongoing investigation? An employer may use a polygraph as part of an ongoing investigation if the employee tested had access to the subject of the investigation and the employer has a reasonable suspicion of the employee's involvement. Question 10. How do courts determine whether AIDS testing is reasonable under the Fourth Amendment? To determine whether AIDS testing is reasonable, courts balance the intrusion the testing would cause on the constitutional rights of the person to be tested with the interest said to justify said intrusion. Question 11. Are any employees whose jobs do not involve public safety subject to discharge for refusal to take drug tests? Because at-will employees can be discharged at any time, employers are free to terminate such employees who refuse drug testing even when their jobs cannot be held to involve public safety. Question 12. For what reasons does the FMLA allow an employee to take unpaid leave? The FMLA allows an employee to take an unpaid leave of up to 12 work weeks in a 12-month period because of the birth, adoption, or foster care of the employee's child, to care for the employee's spouse, child, or parent with a serious health condition, or because of a serious health condition that makes the employee unable to perform the job. Chapter 30, Labor Legislation. Since 1930, the federal government has passed more laws dealing with industrial relations than had been passed during the previous history of our government. Some of the more important of these laws are discussed in this chapter. The Fair Labor Standards Act provides that the minimum wage of workers covered by the Act is set. This amount can be changed through amendments to the Act. Maximum hours at regularly pay are to be 40 hours a week with additional time permitted at time and a half. The major exclusions from the Fair Labor Standards Act are as follows: workers engaged in intrastate commerce, workers engaged in agricultural labor, executives, administrators, and outside salespeople, workers in the transportation industry regulated by the Interstate Commerce Commission for overtime pay provisions. The Fair Labor Standards Act, for the most part, prohibits or severely limits employment of children less than 16 years of age. Contingent wages may not be used to evade the minimum wage provisions of the Fair Labor Standards Act. The Labor Management Relations Act, commonly known as the Taft-Hartley Act, consists of 5 main elements. It provides for continuation of a National Labor Relations Board created by the National Labor Relations Act to hear complaints of employer and union unfair labor practices. It declares the rights of employees to organize, to bargain collectively, to engage in concerted action for their mutual aid and protection, to join or not join a union shop unless a majority of all workers vote for a union shop and the employer agrees. It provides a declaration of the rights of an employer to petition for an investigation when questioning the right of the union to speak for the employees, to refuse to bargain collectively with supervisory employees, to institute charges of unfair labor practices by unions, to sue unions for breaches of the union contract, to plead with the workers not to join the union, provided no threats or promises are used. It prohibits unfair labor practices by employers, such as interfering in the exercise of the rights granted the employees, refusing to bargain collectively with a legally selected representative, dominating or interfering with the formation or administration of any labor organization, or contributing financial support to it, discriminating against or favoring an employee for union activity or lack of it, discriminating against an employee for filing a complaint under the Act. It prohibits unfair union practices such as any coercion or restraint of workers, picketing an employer to force bargaining with an uncertified union, refusing to bargain collectively with the employer, charging excessive initiation fees or discriminatory dues and fees, barring a worker from the union except for non-payment of dues, secondary boycotts or strikes in violation of the law or contract, attempts to exact payment from employers for services not rendered. The Labor Management Reporting and Disclosure Act, also called the Landrum-Griffin Act, has 3 major provisions. It contains a Bill of Rights for union members. It classifies additional actions as unfair labor practices. These actions are as follows: picketing to extort money and for recognition when another union is recognized, secondary boycotts, hot cargo agreements. If it requires unions, their officers, and employers to file annual public reports. Let's do our chapter review questions. Question 1, how does the Fair Labor Standards Act discourage a long work week? The Fair Labor Standards Act discourages a long work week by requiring employers to maintain adequate records and pay time and a half for all hours worked over 40 hours. Question 2, how does the Fair Labor Standards Act seek to protect youth between the ages of 16 and 18? The Fair Labor Standards Act seeks to protect youth between the ages of 16 and 18 by preventing them from working in industries declared by the Secretary of Labor to be particularly hazardous to health. Question 3, how does the Fair Labor Standards Act seek to keep employees covered by the Act who are paid on commission from earning less than the minimum wage for hours worked? The Fair Labor Standards Act seeks to keep employees covered by the Act who are paid on commission from earning less than the minimum wage for the hours worked by requiring the employer to add to the commission enough to bring the total earnings to the minimum wage. Question 4, how did the Wagner Act seek to create bargaining equality between employers and employees? The Wagner Act sought to create bargaining equality between employers and employees by attacking the denial of some employers of the right of employees to organize and the refusal to accept collective bargaining. Question 5, what does the National Labor Relations Board do? The National Labor Relations Board hears and, using subpoena power, conducts investigations of complaints of employer and union unfair labor practices. Question 6, what 4 rights does the Labor Management Relations Act give employees? The Labor Management Relations Act gives employees the right to organize, to bargain collectively, to strike, and to join or not join a union unless there is a union shop. Question 7, under what circumstances does the LMRA allow an employee to be fired for non-membership in a union? The LMRA allows an employee to be fired for non-membership in a union when the union has a valid union shop contract with the employer. Question 8, what are the 3 main provisions of the Labor Management Reporting and Disclosure Act? The 3 main provisions of the Labor Management Reporting and Disclosure Act are a Bill of Rights for union members, classification of additional actions as unfair labor practices, and requiring unions operating in interstate commerce and their officers and employers to file detailed public reports. Question 9, what kind of picketing does the LMRDA declare to be an unfair labor practice? The LMRDA declares to be an unfair labor practice picketing by employees in order to extort money and for recognition when another union is the legally recognized bargaining agent and there is no question regarding union representation. Question 10, how detailed must the union reports listing assets, liabilities, receipts, and disbursements be? The union reports listing assets and liabilities, receipts, and disbursements must be reported in such detail as is necessary to accurately disclose a union's financial condition and operations. Okay, so I know that you listened to this lecture. Please provide me answer 10 to the summary review question in Chapter 30, question 10.